Masechet Sanhedrin Daf Lamed. Hahi odita dava kata beduchran pitka me v'chol ishtane debedina. V'la hava kata ba b'motav telata havena v'chad letohi. Let's say we have a document of admission that generally says we hear the witnesses or the judges saw that this person admitted to that person that he owes him $1,000. Okay, so this would be a valid document, but it's supposed to contain certain standard formulations. So let's say it said Duchran Pitkameh. This is a record of the proceedings. It has that formulation. It also has all the other formulations of a bet din, that it was said in front of a bet din and it was properly accomplished, except it's missing one thing. There's only 2 signatures on it. Now, if it was from a bet din, it should be 3 signatures. Now, that's okay if it said in the document that we were 3 judges in the session, but one is not here. We judged it in front of 3, but one had to go away or he died, and only 2 are signing it. If it said that, then it would be a perfect document, no problem. Nobody would have any problems with it. But it doesn't say this, and there's only 2 signatures. So the question is, should we say that it's no good because maybe only 2 judges were there, and 2 judges is not sufficient? It's not a bet din. If they signed as witnesses, that would be okay as witnesses, but it's written up as a document from a court. And if there's only 2 judges, it's no good. Or can we assume that there were 3 judges, but one died or went away, and that's why he didn't sign, but really there were 3 judges and everything was okay? That's the question. And we have 2 different opinions. Ravina says we can apply the statement of Resh Lakish. We saw that at the end of the daf yesterday, that if witnesses sign on a document, we can assume that everything was done properly. People don't just sign blindly. They look into the matter and they see, everything was okay, and then they sign. And therefore here also, if these 2 judges signed on it, we can assume that they would only sign if there had been a 3rd judge and all the procedure was done correctly. And therefore, even though it does not have the line, we were 3, but one's gone, we can assume that that's what happened. Amar le Rav Natan bar Ameh, hachi amrinan mishmei de Rava, kol ki hai gavna chayshinan lebet din to'in. However, Rav Natan bar Ameh told Ravina, says, no, this is what I heard in the name of Rava, that any case like this, we are worried that it's an erroneous court, that maybe really it was only 2 judges and they thought wrongly that they could make a court with just 2 people. And since they didn't write that there were 3 people, we should assume that there were only 2 people, and therefore the document is invalid. Amar Rav Nachman bar Yitzchak, ikata ba bedina tula sarich. Rav Nachman bar Yitzchak says, okay, I agree with Rav Natan bar Ameh and Rava that normally it would not be good if it didn't have this line, but as long as they wrote something like bet din, they said this was done in front of a bet din, then we don't need 3 judges to sign on it, and we don't need the statement that there were 3 but there's only 2, because as long as they wrote that there was a bet din, then we can assume that they meant 3, and this 1 is gone and is not signing on it. But we ask about Rav Nachman bar Yitzchak, v'dirma bet din chasuf hu, tamar Shemuel shenaim shedanu din din, ela shenikru bet din chasuf. But maybe it's an impudent court, as Shemuel said, if 2 judges judge alone without a 3rd, then according to Shemuel, the verdict is official, but we call it impudent court. In other words, they shouldn't do that. The thing is, halacha is not like Shemuel. So therefore, if 2 people judge, not only is it an impudent court, then they shouldn't have done that. Also, whatever they do, their verdict is invalid. And so maybe they wrote bet din because they thought that 2 is okay, but really it's not okay, and it's an invalid court. And so the answer is no. You're right. If they only wrote bet dina, the document would not be good. But rather, what Rav Nachman bar Yitzchak is talking about is if they wrote tekatabe bedina de Rabbana Asher. We are members of the court of Rav Asher. This is just for example. It could be any great sage, but Rav Asher was known to be a great sage, or anyone like him. So if it's the court of Rav Asher, then presumably they knew what they were doing, and they would not have just 2 people. They had 3 people, and then 1 went away, and that's why they signed 2 people. Then it's valid. V'dilma Rabbanan deber Rav Asher kishmuel sibira lehu. Wait a second. Maybe the rabbis in the Bet Din of Rav Asher follow Shemuel. In other words, we're not talking about Rav Asher himself. He's not necessarily always there, but we're talking about the students, the judges that are part of his betin, and maybe they think the halacha is like Shemuel, and 2 judges is sufficient, even though you shouldn't, but it's valid. But really, we don't follow that halacha, and therefore, even if they're right, the betin of Rav Asher, it should be no good. And so the answer to that is Tichtibo v'amarna le Rabbana Asher v'amarlan Rabbana Asher. No, it says it in the document that we asked Rav Asher, and Rav Asher said to us, right, that this is what we should do. So therefore, it's evident that Rav Asher was directly involved in the case, and certainly Rav Asher knew that halakha does not follow Shemuel, and would make sure that there were 3 judges and not 2. So if you have this formulation in the document, that's also okay, even if it doesn't say the formulation that we were 3, but one of us is not here anymore. Next, we have a baraita continuing on the theme of the laws of admissions. Tenor Rabbanan amalen echad ani ra'iti abichen shetmin ma'ot b'shidati ba umigdal ve'amar shel ploni hen shel ma'aser sheni hen pabait lo amar kelum basadeh deverav kayamin. Someone comes to orphans who inherited from their father, and he said, listen, I saw your father hide money in a chest, a box, or a cabinet. And he told me, here's the admission part, he told me this money that I'm putting in this box belongs to some guy, Mr. So-and-so, I owe him this money. Or he said, I'm putting the money in the box, and it's actually Maaser Sheni money that has to be eaten only in Yerushalayim. So, do the orphans have to believe this guy and give the money over to that person that it's owed to, or use it as Maaser Sheni? It's only one person, it's not 2 witnesses, all right? So maybe we can ignore it. Or, since he knows where it is, and in fact it was there's money that they didn't find before. So he must be telling the truth, because otherwise how would he know that there was money in that very place? That's the question. And the answer is, it depends where the money is. If the money is found in a box in the house, then we can ignore what he said. Thank you for the tip. That now you told us that there's money in this box. We didn't find it yet. Maybe they would have found it anyway. It's somewhere in the house. But because it's in the house, they don't have to believe him that the money belongs to that person or it's Maaser Sheni. However, if the money was found in the field, in a box in the field, then we accept his words. What's the difference if it's in the field? Kilalo shel davar kol shebiyado litelan deverav kayamin and biyado litelan lo amar kelum. The general principle is, if that guy who testified could have gone and taken it himself, if it's in the field, it's accessible. The guy could have he knows where it is. He could have dug up the box, taken the money, and then done with it according to what he thought should be done with it. And he would give it to that person who it's owed to, or use it as Maaser Sheni. So since he could have taken the money on his own, but instead he told the orphans, and they wouldn't have found it, likely, because it was out there, then we believe him, because he could have took it on his own. But if it's in the house where this guy would not have access to get it in the house, so he couldn't have gotten it on his own anyway. So he had to tell the orphans. In that case, he's only one witness, and therefore we ignore his statement, and the orphans can say, thank you for letting us know where the money is, and the orphans can keep it for themselves. Now let's say the children themselves saw their father hide money in a chest, a box, in a cabinet somewhere. And at the time that he was putting the money in the box, he told his children, this money belongs to this Bob. I owe him money. Or it's Maaser Sheni money, we have to eat it in Jerusalem. If he's like someone who's relaying information, and he says, listen, you need to know that this money, one day, if I don't give it to that person or use it Maaser Sheni, I want you to know, right? He's saying it in a matter-of-fact way, then we trust his words, and that money has to be given to Bob or used in Maaser Sheni. However, if it seems that the father is tricking the kids, he might do that because he doesn't want the kids to take the money. So he says, oh, listen, this money doesn't even belong to me. It's Maaseh Sheni money. It belongs to Bob. And that way they won't put their hands on it and take it. So if we think that he was just using artifice to get them not to use it, then we can ignore his words and assume that didn't really belong to Bob. It's not really Maaseh Sheni money, and then the orphans can keep the money and use it for themselves. Let's say a child, an orphan, was distressed about money that his father left. He knows his father left money somewhere, but he can't find it. He doesn't know where it is. And then the master of dreams came, meaning he had a dream at night, and he was told in the dream, listen, there's this much money, it's in this place, and it's Maaseh Sheni money. And then they go and find it. And sure enough, the dream was correct. The money was there. Do we have to assume also that it is Maaseh Sheni money? Because that's what the dream said. The answer is no. There was a case just like this where someone was told in a dream that your father left money somewhere, but it's Maaseh Sheni money, and he went and found it, and he asked, what do I do with it? And the answer was, dreams do not raise up and do not lower down. In other words, dreams are insignificant in terms of halacha. It is true that here the dream happened to be right and told him where the money was, so he got lucky for that. But you don't need to make halachic decisions based on dreams. A dream is not like two witnesses, even though it happened to be right. And so, maybe there's something to the dream, but in terms of legal categories, a dream is not evidence of anything, and therefore the person could just use the money by themselves and do not have to treat it like Maaseh Sheni. The Mishnah said, Shenaim Omrim Zakai, if two of the judges say he's innocent and one says guilty, you follow the majority, and so too vice versa. And now the question is, Michtav Hechi Katveh, when the judges write up their verdict, how do they write it? We're going to see three opinions. Rabbi Yochanan Amar Zakai. Rabbi Yochanan says, the court says you are innocent. You don't specify in the document that there was any controversy about it. Right? The court would, however they decided, and followed the majority. Now they speak as one voice. That's Rabbi Yochanan. This fits together with the halacha we saw in the Mishnah, that none of the judges can come out and say, well, my friends, they said guilty, but I said innocent, or the other way around. They have to speak as one voice, and so in the document it speaks as one voice. Resh Lakish says, we name the people, says this judge and that judge, they said you're innocent. And this judge and that judge, and so however many judges there are, said you are guilty. You have to specify, because otherwise it's not true that everybody on the court said you're innocent. So you have to specify who voted which way. Rabbi Eliezer has an in-between opinion. And he says, from their words, this person ended up being exempted. So we don't say that everybody said one way or another. So it's clear from Rabbi Eliezer's formulation that it was not unanimous, but we also don't name the individual judges who said this way and that way. We just say, as a result of their vote, this person was declared innocent. My benayu, what would be a practical difference between each of these three opinions? The difference would be whether the judge that was in the minority would have to pay up if the court ended up making a mistake. Let's say two of the judges said guilty and one said innocent. And turns out that was a mistaken ruling, and these are not expert judges. And so therefore, their judgment stands, but the judges have to pay out of pocket, right? They said that you are guilty and you have to pay, and this guy ended up paying someone else. But then it turns out they're wrong. So the guy that paid, the judges have to pay him. So let's say they said you're guilty, you have to pay $100, and now they're wrong. And so now they would each pay $33. So it depends on which opinion you follow. According to Rabbi Yochanan, who says that we write just one verdict altogether, whatever it is, innocent, in this case, we would just say guilty. since they all speak as one voice, they are all equally responsible, and even the judge who voted innocent will have to pay up. But according to Resh Lakish, that we name the people, so since you're naming them and it says, okay, these two people said guilty, well, they have to pay because they were wrong. That guy said innocent, so he doesn't have to pay because he gave the right verdict. Why should he have to pay? Now he asks, Ulman Damar Zakai Mishalem. Hold on. According to the Biochanan, that says that we would just write one verdict, does it make sense that you would make the judge in the minority pay up? That judge can say, if you would listen to me and voted with me, then you wouldn't have to pay either. Why should I have to pay for your mistake? I told you that he was innocent, and you guys decided to overrule me, and you were mistaken, and now I have to pay for your mistake? That doesn't make any sense. Rather, the difference is to the two judges that said guilty have to pay also for the portion of the minority judge. In other words, they said you're guilty and you have to pay $100. Now, do they pay just $33 each, or do they pay $50 each to cover the other guy? For sure, that guy doesn't have to pay. He said innocent, and so therefore he shouldn't have to pay because he made the right judgment. The question is, how much will the other two pay? According to the Biochanan, who says we write it as one, so since you write it as one, the litigant has a right to get paid in full. And so the two judges who are responsible because they made the wrong decision, they pay $50 each. In other words, they cover the portion of the minority judge. According to the Shakish, who says that we name them, and since we're naming all of them, therefore the judges that said guilty only pay for their portion. They pay 33 and 33. And then the one who said innocent doesn't pay at all, and neither do the other judges pay for them. Since they're named, they're not all as one, so they're not responsible for the entire thing. They're only responsible for their portion. And so the litigant would only get paid 66 and actually would lose out the other 33. We challenge this answer also. According to the Biochanan, should they have to pay 50 and 50? The two judges who said guilty can say to the judge who was in the minority, if not that you were with us, then there wouldn't be no verdict at all. In other words, you're as responsible as we are because you joined in together with the Beit Din. Even though you ruled differently, if we had only two judges and you weren't here, then there would be no din, no judgment, and no verdict, and then we wouldn't have to pay. So actually, we have to pay because you joined us on the Beit Din. And therefore, even though you voted innocent, the fact that you participated in the court allowed the court to give its verdict, and therefore you should be responsible too, and we should not have to pay 50 and 50 to cover you. Rather, the difference is, do we prioritize the law of not being a gossiper? Rabbi Yochanan says we have to speak as one voice and just say the whole Beit Din said Zakai, because otherwise it's going to be evident that it was not unanimous, and then we're going to have to specify, oh, he said that, which is not allowed. As we said before, no one of the judges can say, I said you were innocent, but they said you were guilty. No, they have to speak as one voice. So Rabbi Yochanan is prioritizing that. Shakish says you have to name the people because otherwise it seems like you're lying if you say the whole Beit Din said guilty, but it's not true. The whole Beit Din did not said guilty, so therefore he prioritizes telling the absolute truth and not making it look like it was unanimous if it wasn't. And even though that will reveal who said what, okay, you have to stick to the truth. Rabbi Elazar itle demor veitle demor hilkach katvi achim midibrehem nizdaka peloni. Rabbi Elazar says, I accept both the concern of Rabbi Yochanan and the concern of Resh Lakish. and therefore he takes care of both. He says, according to their words, the final result was this person was exempt or this person was found guilty. And that way you're not lying because you're saying from their words, you're not saying that they all said the same thing. In fact, you're just saying from the conclusion of all of the deliberation, this person was declared to be innocent. So in that way, you're not lying, but you're also avoiding gossip because you're not specifying who said what. You're just saying, okay, it wasn't unanimous, but we're not going to say this person said guilty and that person said innocent. So that's the best compromise that takes care of all of the concerns. So the Mishnah says that after the litigants present and then the witnesses come in and they warn the witnesses and then they question one of the witnesses without the other one there, and then they bring the second witness in and they cross-examine that witness, and turns out that their words are consistent with each other, and then the judges deliberate. After they deliberate and they vote, that's Kamruat Hadavar, they finish the matter, they reached a decision. Hayu Machnisin, they bring everybody into the court to announce their decision, meaning these people were not in the court beforehand while the judges were arguing with each other. Leman, so now the question is, who exactly are they bringing into the court? Is it the litigants? But weren't the litigants there the whole time? The assumption, according to this opinion, is that we send the witnesses out. We question the witnesses, right? And then first one, then the second one, they're together. And then we send them out during the deliberation. But that the litigants are there the whole time. So who are we bringing back in? It's not the litigants. They sit there during the deliberation of the judges. So rather when it says we bring them back in, them is referring to the witnesses. They weren't there during the deliberation and they have to be present during the verdict. Okay, if that's true, Keman, who would be the author of this Mishnah? The lo could be Natan. It would not be to be Natan, who we're going to see in the second paragraph of the following Baraita, Ditanya. לעולם אין עדותן מסתרפת עד שיראו שניהם כאחד. רבי יהושע בן קורחה אומר אפילו בזה אחר זה. This Baraita has two different machlokot. The first one is about whether two witnesses have to be together when they see the crime or the monetary transaction. Do they have to be there together and see the very same action in order to testify about it? So Tanakama says that the testimony of two witnesses cannot come together unless they witnessed it together. They saw the same event together. That's Tanakama. Rabbi Yosha ben Korcha says, no, even if it's one after another. For example, if one witness saw A borrow money from B on Sunday, and the other witness saw A borrow $100 from B on Monday. They each saw $100, but it was obviously different loans. So even though they actually witnessed two different events on two different days, because both of them are the same in that the same person borrowed $100, they can come together to court and say, we know that A owes B $100, even though they saw on different days him borrowing different actual dollars, but nevertheless, since they saw something equivalent, they can join together, according to Yoshua ben Korcha. Tanakama would say, no, they have to witness the same event on the same day. The second machloket is not about the two witnesses at the time that they saw the event, whether they have to be together or not, but rather at the time that they testify. Tanakama says, we do not accept testimony in court unless they both come and testify together. They have to come into court together and testify at the same time. Although we question one after the other, but they have to present their testimony together in the same session. Rabbi Natan omer shomin devarav shel zeh hayom, uchshevo chavaro lemachar shomin et devarav. Rabbi Natan says, not so. We can listen to the testimony of one today, record everything that they said, remember it, and then tomorrow the other witness will come in, and then we'll give the same questions to the second witness, and we'll remember what he said the previous day. and then we'll know if it lines up or if there are any contradictions. So we see, according to the Binatan, the witnesses do not have to be in court at the same time on the same day. And so this is not consistent with the Mishnah as we just interpreted it, because if you say that we bring them in means the witnesses, that means the witnesses have to be together in court during the time of the verdict. So that means they have to come and be together. But Rabbi Natan says they don't have to be together. One can come in one day, go home, he's finished. And someone else come in the second day. That means they don't have to be together during the verdict. And so we see that our Mishnah is not consistent with Rabbi Natan. And we answer, Lo le'olam le'ba'alei dinin v'Rabbi Nechemya hi. No, in fact, it could be the opinion of Rabbi Natan. And when it says we bring them back in, it's not referring to the witnesses. The witnesses, one came yesterday, he doesn't have to come back. Rather, when it says we bring them in, it's referring to the litigants. And this would follow the opinion of Rabbi Nechemya. Tanya Rabbi Nechemya Omer Kachaya min agan shaniki hadat shebirushalayim machnisin leba'alei dinin v'shomin dimrehem machnisin et ha'edim v'shomin et dibrehem mosin otan lachus v'nosim otim b'dabar gamrut ha'dabar machnisin otan v'chule. There is a baraita that teaches that according to Rabbi Natan, the custom of the scrupulous people, judges in Yerushalayim, is as follows. They would bring the judges would be there. They would bring in the litigants and listen to the litigants in turn and in front of each other. And then they would bring in the witnesses and they would listen to the witnesses, first one, and then they would bring the other one in. And then they would send everybody out during the deliberation. And this would be important so that the judges, when they are asking each other questions and bringing proofs and everything that they do, that should be done in private so that a judge won't feel embarrassed in front of a litigant and the litigants are going to get involved. No witnesses, no litigants should be there while the judges are deliberating. And then once they reach a verdict, then they bring in the litigants. And so that's what the Mishnah is referring to, bring in the litigants, and has nothing to do with whether the witnesses need to be there or not. So therefore, the Mishnah could be, in fact, according to the Rabbi Natan, who says that the witnesses do not need to be there on the same day. Now we ask, a challenge against Rabbi Natan from a baraita that says, when they finish the verdict, they bring the witnesses in. That means the witnesses are there on the same day. So what's Rabbi Natan going to do? The look at Rabbi Natan. That baraita is not Rabbi Natan. Rabbi Natan is a Tana. He doesn't have to agree with every baraita. So that baraita follows a different opinion. But Rabbi Natan would say that they do not call in the witnesses because the witnesses don't even have to be there on the same day. Gufa le'olam en adutan mistarefet ad shi'ir'u shenehem ke'ahad. Let's go back and analyze that baraita that said that the testimony does not join together unless they both saw the incident together. This is the first machloket in that baraita. Rabbi Yoshua ben Korcha omer afilu bezeh achar zeh. Rabbi Yoshua says that the witnesses could have seen the incident at two different times. $100 that he borrowed today, $100, and another witness about $100 he borrowed tomorrow. And even though they are witnessing different events at different times, that's okay, they can still join together. Now we ask, we can explain their machloket based on two interpretations of a pasuk, or maybe it's just a difference in logical reasoning. Let's start with the logical reasoning. The Tanakama would say about the 100 dinar that this guy is testifying about that was borrowed on Sunday. The other guy is not testifying about because he wasn't there on Sunday. And the one who's testifying about the 100 dinar that was borrowed on Monday, there's only one witness. The other witness who was there on Sunday does not see this one. So therefore, they are testifying about two different things. So therefore, they cannot join together. That makes sense. Rabbi Yoshua ben Korcha says, even though they're testifying about different 100 dinars, Nevertheless, they're both testifying about the same thing, that the same result, that this guy owes that guy 100 dinars. So even though it's based on what they saw on different days, different events, but they're coming to court and saying, we testify, and they can both say this with absolute truth. We testify that this person owes that person 100 dinar. They're not testifying that he owes him 200. We're not joining together both events because there's only one witness for each event. But they can join together for the resultant verdict that this person should give that person 100 dinar. And they can join together, even though they're not joining together for what they saw, they can join together for what they're claiming. Or maybe they disagree about how to interpret the following pasuk that says, if someone commits a crime and there is a witness and the witness saw it and knows about it, and he does not come to court to testify about it, then he bears sin. Someone who knows testimony has to come and say it. Now, regarding that pasuk, is a braita v'tanya. Mashma shene'emar lo yakum aed eni yodea shehu ehad, ma tamod lomar ehad. On the pasuk in Devarim that says, lo yakum aed ehad, one witness cannot testify about something. Rather, it has to be at least two witnesses. Now, from the fact that you said the word ayed, which is in singular, don't I know it means one? Why do you have to say ayed echad? That seems redundant. Ze bana av, kol makom shenemar ayed, hare kan shenayim, ad shefretecha katub echad. And so the answer of this midrash is that this is a paradigm for all other places, that anytime you see the word ayed, even though it's in singular, you have to interpret it as two witnesses, unless it says ayed echad. So it says lo yakum ayed echad here, even though it's clear it's only one, to teach you that ayed means two, unless otherwise specified as one. Okay, now if we apply that back to this pasuk over here that says v'hu ayed, hu ayed, this even though it's in singular, we just learned that we have to treat every ed as plural, unless it says otherwise, and it doesn't say otherwise here. So this is referring to two witnesses that saw something. They have to come forward. Now, according to Tanakh, they're saying, why does the Torah use a singular when it could equally use a plural? Vehem edim. So it's using a singular to teach us that they can only come together and testify if they saw it at the same time. And that's the proof for Tanakama. What are they going to do with that? How would he explain the singular here, which still refers to two, but why use a singular? And the answer is v'hu ed or ra'a or yada mikol makom. And he says, look at all the extra phrases. He is in ayed, and maybe he saw it or he knows about testimony. He has to come and say it. From all the extra phrases, we learn that no matter what, whether they saw it at the same time or whether they saw it at different times and they saw different events, nevertheless, they can join together and testify about it. So that's how they are differing in their interpretation of the pasuk. Now we're going to continue and analyze the other part of the baraita. This is not about what they witnessed, but now when they come to testify, Tanakama says that they have to come and testify together. Rabbi Natan says that one can testify today, and the other person, the other witness, can come and testify tomorrow. What's that the essence of their machloket? You can explain it both based on reason and based on a pasuk. Again, we're going to start with reason. Tanakama says, when one witness comes, his only power is to make the other party give an oath. If one party says you owe money, then the other party has to give an oath that they don't owe money, and that's it. But one witness by himself cannot extract money, and therefore, if one witness comes today, they can't do anything about money, only about a vow. And therefore, if you want to extract money, then you need two witnesses to come together. If they're not coming together, then they have no power over extracting money, even though he's coming on the next day. Ve'idach, Rabbi Natan, how would they respond to this reason? Atu bahadeh hadadeh bechad puma kama sadeh ela mistarfin lehu hachanami lisarfinhu. He says, even when witnesses come together, they show up to court, right, holding hands together, and they're coming on the same day. Do they speak with one mouth? No, they don't. One of them is questioned first, with the other one not in the room, because they can't hear. The second one can't hear what the first one said. Otherwise, they'll just copy the same answers. Rather, we listen to one first, the older one first, and then we bring in and we listen to the second one separately. And then we combine them together. We say, okay, they match up, and we heard both of them. So just like in a case where they come in together at the same time, they speak separately, and the judges say, okay, we'll combine them. So too, what's the difference if there's 24 hours between them and we heard one today and one tomorrow? The judges will be the ones to combine the testimony together, which also makes sense. This is the continuation of the pasuk over here. If someone knows testimony and they don't say what it is, right? Imlo yagid, then they bear sin. What you see is that the first half of this pasuk is talking about seeing the crime or the event, and the second half of the pasuk is talking about coming and testifying in court. So, and since the two parts of the pasukim are right next to each other, the question is, should we learn from one to the other? Now, everybody in the second machloket in the Baraita, between the Tanakama and the Binatan, they all agree with Tanakama in the first machloket regarding the time of the witnessing. The witnesses have to be together to witness the same event. They both disagree with Rabbi Yoshua ben Korcha that you can join together if one witnessed today and one witnessed something else tomorrow. Okay, so for the witnesses, when they see the event, they have to be together. Everybody agrees with that. One opinion says we compare the two, and this will be Tanakama, and say, just like when they witness the event, they have to be together, so too when they're magid, right, as the pasuk says here, lo yagid, if they don't testify, so too when they testify, they have to be together, because we compare the two, since they're both back-to-back in the same pasuk. Whereas Binatan says, no, we don't compare them. And it's different, although the observation has to be that they are together because they have to see the same event. That makes sense. But when they come into court, they're not testifying at the same time anyway. So it doesn't matter if there's a 10-minute difference between them or if there's a whole day difference between them. They can testify one after the other. And now we have a great story about Rabbi Shimon ben Eliakim. Hava mishtaked Allah Rabbi Yosef Rabbi Chanina lemismeche. Rabbi Shimon ben Eliakim really wanted to give semicha, rabbinic ordination, to Rabbi Yosef Rabbi Chanina. However, he had a tough time doing so. He was not successful. He kept trying, and he was trying to get the other rabbis to give him semicha, and they said, not today, tomorrow. Maybe they thought he wasn't really so qualified, and so they kept pushing it off, and he was not able to give what we call him a Rabbi Yosef. So you see, eventually he got semicha. So here's how it happened. Yom achad havayateb kameh to Rabbi Yochanan. One time, Rabbi Shimon was sitting before Rabbi Yochanan as a student. Amar lehu mi'ika diyada halachak Rabbi Yoshua ben Korcha olo. And Rabbi Yochanan asked the crowd, the students there, does anybody know whether halakha is like Rabbi Yoshua ben Korcha, that witnesses can observe an event on different days, one witness each, and then they can still join together? Or is it not? Is it like Tanakama, that they have to observe the same event on the same day? Amarle Rabbi Shimon ben Eliakim den yada. Rabbi Shimon says, no, I don't know, but you know who does know? Rabbi Yosef Rabbi Chanina. Amarle lema ezo. So Rabbi Yochanan says, okay, let him come and tell us what he learned. Amarle lismechemor beresha. Rabbi Shimon ben Eliakim used the opportunity and says, oh, you need his information? First give him semicha, and only then will he tell. And so Rabbi Shimon, who was trying for a long time to get semicha for Rabbi Yosef, now took this opportunity because Rabbi Yosef has knowledge that everybody else needs. So he certainly therefore is worthy of getting semicha, and so Rabbi Yochanan gave him semicha. Amale beni emorli kesat shamata. Says, okay, now I gave you semicha. Now tell us, what tradition do you have about whether halacha is like Rabbi Yoshua ben Korcha or not? Amale kach shamati shemodeh Rabbi Yoshua ben Korcha Rabbi Natan. He says, I heard a tradition that Rabbi Yoshua ben Korcha agrees with Rabbi Natan. Rabbi Yoshua ben Korcha said that two witnesses can join together even though they observed something on different days. And he agrees with Rabbi Natan that witnesses can come into court and testify on different days. That's what he heard. Now this doesn't really answer the question, because just because Rabbi Yoshua ben Korcha agrees with Rabbi Natan doesn't tell us anything about whether halacha is like Rabbi Yoshua ben Korcha or not. Amar lazeu srachti Rabbi Yochanan was disappointed. Says, this is what I needed. I needed to ordain him to hear this. I knew this already. Hashta uma ikar aya b'hadeh amar Rabbi Yoshua ben Korcha la ba'inan hagada mi ba'ya. In fact, I could figure it out from a kal vachomer. If the essence of the proof, the observation, Rabbi Yoshua ben Korcha says witnesses do not have to observe at the same time, then all the more so, Rabbi Yoshua ben Korcha would agree that when it comes to testifying in court, that they do not have to be together, right? It's much more of a chidush that they can observe something separately. If you think they can observe the original event separately, which is the proof itself, then for sure it's easy sell to say that they can come into court and testify together. And therefore I could have figured that myself. You did not help me at all. However, since you were raised up, in other words, since you got semicha, okay, don't go back down, even though had I known that you really were not helpful at all, I would not have given you semicha in the first place. But now that you got semicha, you can keep it. Amar Rabbi Zera shemamina kabra rabba kevan desmich semich. Rabbi Zera says we learn from here that a great person, once he's ordained, he keeps his ordination. We don't cancel it retroactively because he said an error or because something went wrong. Rather, he's still a great person. So he keeps the semicha. Amar Rabbi Chia bar Abin Amar Rav halacha Rabbi Yoshua ben Korcha ben bekarkaot ben bemetartelin. So Rav thinks that halacha follows Rabbi Yoshua ben Korcha both regarding land and regarding movable property. So halacha is like him, and witnesses can testify to what they observed on 2 different days or 2 different events, but if they have the same legal outcome, they can join together in testimony. Ula disagrees, and he says we follow halacha like Rabbi Yoshua ben Korcha regarding land, but not movable property. What's the difference? Regarding land is there, it's stable, it doesn't move, and we can easily identify it. Therefore, if one witness comes and says, on Sunday, I heard this guy admit that this land belongs to that person. And then on Monday, one witness hears the same guy say, I admit that this land that I have belongs to that other person. So these were 2 different admissions. One happened on Sunday, one happened on Monday. But they line up in that the legal consequence will be the same. Since it's talking about land, and so it's obvious they're talking about the same piece of land. Land doesn't switch, doesn't move. And therefore, we'll follow Rabbi Yoshua ben Korcha regarding land. But when it comes to movable items, just because on Sunday someone said that this bike belongs to that person, and on Monday he said the same thing, was he referring to the same bicycle? Maybe he was talking about a different one. Things that move around are not so sure, so we cannot join together things for movable items, although we can for land. Amar le Abaye, halacha mikela de plike. Abaye challenges Ula. You're telling me, halacha is like Rabbi Yoshua ben Korcha regarding land. If by saying that, you're inferring that there is someone who would disagree. But Abaye says, actually, nobody disagrees about land. V'amar Rabbi Abba amar Rav Huna amar Rav. Modim chachamim le Rabbi Yoshua ben Korcha bedut karka. We have a tradition in the name of Rav that the Chachamim agree with Rabbi Yoshua ben Korcha when it comes to testimony about land. And so there's nobody even disagrees. Chachamim themselves, who say that you need the witnesses to observe the same event, they themselves agree with Rabbi Yoshua ben Korcha when it comes to land, that the observation can be on different days, and therefore there's no need to say halacha k'Rabbi Yoshua ben Korcha bekarkaot. Furthermore, v'tane Rav Idi bar Avin ben Nezikin tebe karna. We have a support for what Rav said, that Chachamim agreed Yoshua ben Korcha when it comes to land, from the following halacha that Rav Idi bar Avin learned, and that was taught in the school of Be Karna regarding Nezikin. This is interesting in and of itself, that in this school of a sage called Karna, they had a collection of halachot regarding Nezikin that were memorized. And Rav Idi bar Avin knew it, and he related. Here's what they taught: Modin Chachamim l'Rabbi Yoshua ben Korcha be'edut bechor, u'be'edut karka, u'be'edut chazaka, v'chen shebaben v'shebabat. Here the list is expanded, and it says Chachamim agree with Rabbi Yoshua ben Korcha that witnesses can testify about separate events, something that they saw on different days or different times. And they agree with Rabbi Yoshua ben Korcha that you can do that when it comes to the following areas of halacha. Regarding the firstborn of an animal, if a firstborn animal has no blemish, has to be given to a kohen. If it has a blemish, it has to be given to kohen no matter what. If it has a blemish, the kohen has to sacrifice it, and he gets to eat only part of it. If it has a blemish, then the kohen can eat the whole thing himself, doesn't have to sacrifice it. So, therefore, it's beneficial to the kohen that it has a blemish. In order to say that it has a blemish, so it has to be checked out. Now, let's say the typical case would be there's two witnesses that saw a blemish, and they can testify, yes, we saw this thing has a blemish. But what if there's one witness that saw a blemish and a second witness that saw a different blemish? Now, there are two witnesses, even though they saw two different blemishes, but the result is the same because they're both testifying that the animal can be slaughtered without being sacrificed. So everybody would agree that you can join together the testimonies in such a case. Edut karka is the case we were talking about, where someone admits, I owe this land to someone on Sunday. He makes another admission on Monday, and each one is observed by one witness and one witness. Yes, they can join together. Also, edut chazaka, regarding if someone's claiming I was here for 3 years using this land and nobody bothered me, and this is how I got it because I bought it from you. You need proof that you were there for 3 years. Let's say I have one witness that says, I saw that you were there in years 1, 2, and 3 of a Shemitah. And another witness comes and says, I saw that you were there years 4, 5, and 6. Now, they're not the same years that they're testifying about, but the result is the same, that he was there 3 consecutive years without anybody protesting. And therefore, they can join together. And also, regarding a boy or a girl, in order to know that they have reached adulthood, we need to, witnesses need to observe that they have 2 pubic hairs. And so, if one, we're going to see exactly what are they saying? Do they each see 1 hair, or do they each see 2 hairs, but in different places? We'll discuss that in a second. Anyway, the point of this is that Abaye is challenging Ula. Ula, why are you saying halachas like Rabbi Yoshua ben Korcha regarding land? Everybody agrees that you can accept 2 separate witnesses and during the observation when it comes to land. So you don't need to say that. And the answer is Gabra karamit, mor sabar pelige, or mor sabar la pelige. You're asking a question from one Amora, Rabbi Abba, in the name of Rav, to another Amora Ula. Amoraim don't have to agree with each other. Now, it's true this is called a Taneh, which usually refers to a Baraita. But in this case, it seems to be referring to a memorized tradition from the school of Karna, which does not have the status of a Tanaitic Baraita. So the point is that Ula can disagree with these traditions, and while one master says that they disagree, that would be Ula. Ula thinks that Chachamim would disagree with Rabbi Yoshua ben Korcha in all cases, karka and metaltelin. So that's why he has to come and say halachas like Rabbi Yoshua ben Korcha regarding land, even though Chachamim would disagree. but halacha is like him. Whereas Rabbi Abba says in the name of Rav, not in the name of Rav, he thinks that Chachamim agree with Rabbi Yosha ben Korcha. Okay, Chazaku Baruch to him that he thinks that they agree, that's fine. So and that will be the halacha, but Ula doesn't have to accept that there is agreement. He thinks that they disagree. And nevertheless, halacha follows Rabbi Yosha ben Korcha when it comes to land. Now we clarify, Mai v'chen shebaben v'shebabat. What is the case exactly regarding testimony of hairs on a boy or on a girl to know that they are considered adults? Ilem achad omer achat begaba, v'achad omer achat bekresa, hay chatzi dabar v'chatzi edut hu. If one witness says, I saw one hair on her backside, and the other one said, I saw one hair on her front side, well, in that case, each testimony is only about half a matter. In order to be considered an adult, you have to have two hairs, and each of them only saw half of the testimony that's required, meaning that the half of the actual requirement of two hairs. And so testifying just about one hair is half of a testimony, which is nothing. Rather, one witness says, I saw two hairs on her backside. And the second witness says, I saw two hairs on her front side, even though they saw different hairs, but they both saw two hairs. So therefore, they can join together because the result is the same. If we accept one or the other, she is an adult, even though they saw different sets of testimony, different sets of proof, different sets of hairs. Nevertheless, they can be joined together. So that's the case that it's talking about. Amar Rav Yosef, Ana Amina Mishmeh de Ula. Rav Yosef has a different version of Ula's statement than the one that we just saw. In his version, Ula declared, Halacha Kerebi Yoshua ben Korcha ben bekarkaot ben bemetartelin. Ula said halacha follows Yosha ben Korcha, both regarding land and also movable property. In the previous version, Ula said halacha is only like Rabbi Yosha ben Korcha regarding land, but not movable property. Now the rabbis that came from Mechoza, a different one of the yeshivot in Bavel, they said in the name of Rav that the halacha is like Rabbi Yosha ben Korcha bekarkaot in avalo bemetartelin, only in land but not regarding movable property. In other words, this version of what Rav said would be the same as what Ula said earlier. Rav leta'ameh damar Rav, hoda'a achar hoda'a, hoda'a achar halva'a mistarefeh, halva'a achar halva'a, halva'a achar hoda'a la mistarefeh. Now Rav is consistent with another statement that he said, because Rav said that if you have an admission following an admission, meaning one witness testified that someone admitted he owed $100 to someone else on Sunday, and then a second witness says, I saw this person admit he owes $100 to that same person on Monday. These are two different admissions. Rav says they can join together. Why? Because it's likely that he was talking about the same $100 on Sunday and on Monday, and therefore they can join together. And also, if it's an admission after a loan, so one witness says, I saw this person borrow $100 on Sunday. On Monday, he admitted that he owes $100. Well, then that also is referring to the same $100, and therefore they can join together. That's the same as a case of karka, of land, where if someone is saying something about land, this land belongs to that person. He says it on Sunday and he says it on Monday, each time in front of one witness and then another witness, then they can join together because he's talking about the same land. So you see, that's consistent. And Rav continued and taught, if someone saw a loan and then another loan, on Sunday one witness saw a loan, and then on Monday, another witness saw another loan of the same amount between the same people. Those do not join together because obviously these are two different loans, two different actual monies. And so that would be the same as metaltelin, movable item where what you're talking about today is probably not the same thing that you're talking about tomorrow. And so the two witnesses cannot join together, because although the result is that this guy owes $100, but the testimony is about two different $100, so they cannot join together. And also, halva achad hoda'a la mistarfeh, if on Sunday one witness saw this guy say, I admit I owe $100. On Monday, he borrowed $100. Evidently also there, it's a different $100 than the admission, because that admission on Sunday was for a previous loan, and now there's a new loan on Monday. They don't join together. And so Rav, who makes a distinction over here between land and movable objects, makes sense. He would make a distinction also between these cases, because in the first two, it's likely that it's the same actual money that he owes. In the second two, it's obvious that it's different money that he owes. Ashkache Rav Nachman bar Yitzchak l'Rav Huna bered Rav Yoshua Amale Ma'ishena halva'a achad halva'a delo demane dekachaze hai la kachaze hai hoda achad hoda aname amane dekamode kame hai la mode kame hai. So Rav Nachman bar Yitzchak found Rav Huna, the son of Rav Yehoshua, and Rav Nachman said, "Can you please explain to me these halachot that we just said? What's the difference between the case of a loan after a loan, where you said no, right? And why'd you say that the witnesses cannot join together? Because the 100 dinar that was testified about on Sunday is obviously not the same as the 100 dinar that was testified about on Monday, because these are loans, and so each loan is a new $100, and so therefore they don't join together. I understand that, but how is that different from an admission after an admission? It's the same thing. Could very well be that the admission that was made on Sunday was about a certain $100, and the one on Monday was about a different $100, since he did not admit in the presence of the other. In other words, since it was only one witness on Sunday and one witness on Monday, maybe the person making the admission was referring to two different obligations that he had to the same person, and he was admitting one thing based on one loan that he had taken out previously. On a Monday, he was admitting regarding a different loan or a different reason why he owes him money. And how do you know that they can be combined? Because how do you know it's talking about the same $100? Damale lahai batra behai mane de odie le kamach odie le name kame peloni. Rav Huna answered the question and said, we're talking about a case where the person making the admission tells the second witness on Monday, it's with regard to the same 100 dinar that I admitted owing to you, I also admitted in front of this other witness yesterday. So therefore, the person making the admission tells him that it's the same $100. It's the same loan that he's talking about when he admitted yesterday and today. Okay, so far so good. But Nachman continues to press. Akate batra yada kama la yada. That's good for the second witness. The second witness knows that he heard about the admission, the same admission that the first one heard about. But that won't help for the first witness. The first witness doesn't know that the admission that he heard is the same as the second one. And in order for testimony to join together, both witnesses need to know the full story and need to know that the other witness also knows that it's talking about the very same thing. But only one witness heard the fact that the two admissions were about the same money. And so one witness about that is not sufficient. You need both witnesses to know that the admissions on Sunday and Monday were about the very same obligation. So Rav Huna answered, "Dehadar azil amar le lekama, haymane de odie le kamach, odie le name kame peloni." Oh, we're talking about a case where the person who made the admission also went back to the first witness after he testify in front of the second witness. So he went back on Monday afternoon or on Tuesday, and he says, I want you to know that the 100 dinar that I admitted to you is the same 100 dinar that I admitted to this other witness on Monday. And so now both the witness on Sunday and the witness on Monday not only heard the admission, but also heard that the admission that the other guy heard was about the same financial obligation. So this answer was acceptable. Amare Ale, Rav Nachman said to Rav Huna, Tanuach da'atach shehit nachta et da'ati. Your mind should be settled. You have settled my mind. I was all worried about this and thinking about it, and you gave me a good answer. Thank you so much. Amale Mainichuta. And now Rav Huna, who's the one that gave the answer, said, why are you so happy? Actually, the answer I gave you, that there is a problem with it. So what's the problem? Rava v'itema Rav Sheshat shadaba narga. Rav Huna says that I talked about this with Rava or Rav Sheshat, and they threw an axe into my answer. And they said, Lav hainu hoda'a achad halva'a. If you interpret the way we just interpreted, that hoda'a achad hoda'a is talking about a case where he admitted on Sunday, admitted on Monday, and he told the witness on Monday it's the same as what happened on Sunday, and he told the witness on Sunday it's the same one on Monday. Well, then that would be equivalent to a case of admission after a loan. And why would Rav have to mention Hoda'a achad hoda'a as a separate case from Hoda'a achad halva'a? Because Hoda'a achad halva'a, if he says, what I'm admitting today on Monday is the same as the loan that happened yesterday, so then it's the same story. It doesn't really matter whether one is a loan or the first one was an admission. So why would he have to say two things? Amar le hainu deshemiya lialaychu teremitu dikle v'zakfitu lehu. Rav Nachman says, now I understand what I heard about you. Your reputation is that you knock down palm trees and then you erect them. You destroy problems and then you bring problems back up. You're never happy with just, leaving it. You have an answer. Okay, good. And so you gave me a good answer. My mind was settled. I was so happy. And now you're destroying that very answer that you yourself gave me. And so that's the character trait of Rav Huna, which is a good character trait, that he's never settled just because he found an answer. He always wants to know the truth, and therefore he always looks for problems with his answer so that then he can find new solutions and understand the Torah even better. Finally, Nehardea Amre Ben Hoda'a Achad Hoda'a Ben Hoda'a Achad Halva'a Ben Halva'a Achad Halva'a Ben Halva'a Achad Hoda'a Mistarfot Keman Kirabi Yoshua Ben Korcha. Sages of Nehardea say that the bottom line is that it doesn't matter what the case is, if whether it's an admission after admission, or admission after a loan, or a loan after a loan, or a loan after admission, it doesn't matter. In all cases, they join together. How could they join together? That means that Nehardea, they think that halacha follows Rabbi Yoshua ben Korcha across the board, no matter what. And so even if the two witnesses originally saw two different events, a loan on Sunday and a loan on Monday, they're not the same. It's not the same financial obligation. Doesn't matter. As long as the result is the same, that this guy owes 100 dinar to the other guy, they can join together and testify together. Baruch Adonai le'olam. Amen ve'amen.